call to order. We have first for our consideration the minutes of November 21. Does anyone have any questions or comments on the minutes as presented? Hearing and seeing none, could I have a motion to approve same, please?
So moved.
Moved by
Second.
Commissioner Bunn, seconded by Justice Long. Any discussion? Hearing and seeing none, all those in favor? Aye.
Aye.
Opposed? Okay, thank you. We will proceed with our agenda, but for the as a courtesy to the members of the public, should let you know that there is some additional work to be done in connection with item 3, which referenced 2C:24-4, the constitutionality of the definition of, quote,
Right.
portray a child in a sexually suggestive manner, close quote. So that will be pulled from our agenda and will be considered when ready at a later date. Otherwise, we will proceed with the agenda as spread before you. The first item is the driving while intoxicated project. And for that, I turn to Kyle Ryan.
Thank you, Chairman. Thank you, everyone, for your time. Good afternoon. This is going to be a draft final report recommending modifications to 4 statutes related to New Jersey's driving while intoxicated, or DWI, offense. The modifications here are intended to correct anachronistic references in these statutes to bring them into compliance with 2 reorganization plans that transfer duties and powers referenced in the statutes to alternate state entities. The reorganization plans affected the governance of 1, the preparation of standard statements for the refusal to submit to a breathalyzer test, and 2, the administration of the Drunk Driving Enforcement Fund, or the DDEF. A 1977 amendment to the refusal statute added a provision containing a standard statement that detailed the consequences of refusing a breathalyzer test. Responsibility for creating the statement was delegated to the Chief Administrator of the New Jersey Division of Motor Vehicles at that time. Similarly, the DDEF was created in 1984 and was to be administered by the Director of the Division of Motor Vehicles. The DDEF is funded by a surcharge imposed on those convicted of a DWI offense and those to refuse an alcohol presence test. In 1992, a reorganization plan transferred the authority to administer the DDEF from the Director of the Division of Motor Vehicles to the Division of Highway Traffic Safety. And in 2009, another reorganization plan transferred all responsibilities related to the preparation of that standardized statement from the DMV to the Attorney General's office. References to the Chief Administrator and Director of the Division of Motor Vehicles currently remain in the statutes identified in this report, even though the responsibilities and powers were transferred by the reorganization plans, and the Division of Motor Vehicles has now been reorganized as the Motor Vehicle Commission. Outreach on this issue was conducted to knowledgeable and interested parties, including the New Jersey Office of the Attorney General, the Division of Highway Traffic Safety, and the Motor Vehicle Commission. Mr. Steve Slimowicz, the state coordinator for the DDEF, provided comment in support of the proposed modifications, but noted that the Division of Highway Traffic Safety is a division, not an office, and the report was updated appropriately to reflect that. Ms. Emily Armstrong, Assistant Administrator for Legal Affairs with the Motor Vehicle Commission, provided a brief comment expressing support for the proposed modifications as well. And at this time, there's been no additional response to outreach. There are currently no pending bills which seek to correct the anachronistic references in NJS 39-4-50.2. Similarly, there are no pending bills which would amend the language of NJS 39-4-50.8, 39-3-10.24, or 12-7-55. In conclusion, the recommended modifications, which are set forth in the appendix of the report, are intended to update anachronistic and potentially misleading references in the aforementioned statutes in accordance with the 1992 and 2009 reorganization plans. Thank you, and I'm happy to answer any questions.
Thank you very much, Kyle. Does anyone have any questions or comments in response to Kyle's presentation? Okay, this is excellent, is a clean, classic Law Revision Commission project. Appreciate your work on this. Since there are no questions or comments, I would ask for a motion then to release this as a final report.
So moved.
So moved.
Moved by Commissioner Bunn, seconded by Professor Bell. All those in favor?
Aye.
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 Opposed? Excellent. All right. Kyle, thank you very much. The next item on the agenda is the project involving the use of surrender rather than the preferred term relinquish in the context of voluntarily relinquishing parental rights. And for that, we turn to Whitney.
Actually, I'll be speaking on that today, Mr. Chair.
Okay.
Today I'm going to be talking about a draft final report for the use of surrender in the context of the relinquishment of parental rights.
Now, wait a second. Is the background, is that Bayonne or the North Pole? That's what's not clear to me.
Oh, you wish. I bring the magic. I try.
That's impressive.
Well, thank you.
Good, sir.
So, in the context of adoption of a child, the term surrender appears in 19 statutes concerning parental rights across Title IX and Title 30 of the New Jersey statutes. Surrender is defined in the statutes concerning adoption as a voluntary relinquishment of all parental rights by a birth parent, previous adoptive parent, or other person or agency authorized to exercise these rights by law, court order, or otherwise, for the purposes of allowing a child to be adopted. So the State Bar Association requested that the Commission consider replacing the word surrender with an equivalent term to more accurately reflect the proceedings and protect the dignity of biological parents. The use of the term surrender is often associated with giving up power and control to another. In the context of parental rights as outlined in Titles 9 and 30, this creates an additional emotional obstacle for biological parents to overcome when they're considering relinquishing their rights to a child. So staff engaged in detailed research of the terminology used in 15 other jurisdictions to determine the feasibility of replacing the term surrender. The most common alternatives included transfer or relinquish. And at the April 2024 meeting, following the discussion of the project, which included input from members of the public, the Commission authorized further research and outreach with a focus on the term relinquish rather than transfer as a suitable replacement. So as for relinquish, in multiple jurisdictions, the term relinquishment is utilized in reference to the parental rights to a child. Meanwhile, other jurisdictions use the term relinquish in reference to the physical custody of a child. The New Jersey Court Rules 5:10-7 dictates that the use of the word surrender in New Jersey statute relates to both the physical custody as well as the termination of parental rights. Therefore, under New Jersey law, surrender and relinquish are synonymous. There are currently no pending bills in New Jersey that propose replacing the term surrender in the 19 statutes included in the appendix of the report. And as for outreach, staff sought comments from a variety of knowledgeable individuals in fields relevant to this area of statutory revision. Professor Lizette Diaz, an associate clinical professor at Seton Hall University Law School, advised that she agreed with the proposed changes. And Mary McManus Smith, the chief counsel for family law at Legal Services of New Jersey, also expressed her support for amending the statutes as proposed. So in your appendix, you'll see that in 19 statutes, the word surrender was replaced with relinquishment. In 3 statutes, additional edits were made to make the statutes gender neutral. And in statute 9:3-38 section J, this has been updated to define relinquishment as a termination of all parental rights. So subject to the Commission's discussion today, staff requests authorization for this report to be released as a final report.
Thank you very much. All right. Do any members of the Commission have any questions or comments? Okay. Thank you very much.
We have Commissioner Hartnett. Did you have a comment?
Yeah, just one teeny nit.
Sorry, I didn't see you.
Yeah, no, I'm sorry. I didn't get my hand up in time. One small nit on page 7, second full paragraph, second line. There's a typo in statutes.
Yep. Got it. We will make that
Okay.
change. Thank you.
Yes.
Thank
You are good.
That is, I agree. Very professorial of him, don't you think? Any other questions or comments? All right, oh, wait a second, hang on one second. I just feel the need to compete, so I just have to do this for a second.
Don't do this, Vito. The rest of us are gonna have to do it now.
I'm sorry.
This is the
Um,
Charlie Brown version of the tree, though.
Yes, correct. You see the Linus blanket. Very, very, very good, Commissioner Bund. All right. As a tribute to JC's excellent presentation, could I now have a motion to release this as a final report?
So moved. Second.
Moved by Commissioner Bertone, seconded by Justice Long. All those in favor?
Aye.
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 Opposed? Okay, motion carries. Thank you very much. All right, as I mentioned, the item listed as third on the agenda is removed from the agenda for revision and consideration at a later date. The next item on the agenda, therefore, is the New Jersey First Act residency requirements application to unpaid volunteers. And this is yours, Barbara.
Good afternoon.
afternoon.
This is a draft final report proposing modifications to NJS 5214-7A, clarifying the state residency requirement under the New Jersey First Act. NJFA does not apply to unpaid volunteers. The statute establishes a state residency requirement for persons holding office, employment, or a position within state or local government. In Cradaville versus Angelson, the Superior Court addressed, as a matter of first impression, whether unpaid volunteers are subject to NJFA's residency requirement and whether the 360-day provision allowed for a rolling cause of action. The court specifically analyzed these issues as applied to members of the Rutgers University Board of Governors who did not maintain a principal residence in New Jersey for at least a year. The court held that the NJFA did not apply to unpaid volunteers since they are not compensated pursuant to New Jersey Statute 18A 6517. The Cradaville Court also found that the scope of the terms office, employment, or position excludes unpaid volunteers. Other sections of the NJFA, such as 5214-15A, define any person holding public office, position, or employment as employees who are paid. The court also noted that the legislature intended the residency requirements in the NJFA to help improve economic conditions in the state and encourage employment for New Jersey residents, particularly after the 2008 economic recession. The court determined that the phrase any 365-day period allows for the cause of action alleging non-residency to arise in rolling or successive periods due to the modifying the word any before 365-day period. 5 bills are pending that involve this particular statute. There's a pending Senate bill and an identical Assembly bill. The proposed bill seeks to narrow the class of covered individuals to include only the governor, the legislature, the head of each principal department of the executive branch of state government, and every justice of the Supreme Court, judge of the Superior Court, and judge of any inferior court. Identical versions of this bill have been introduced in prior legislative sessions. In connection with this report, staff sought comments from knowledgeable individuals and organizations, including the Board of Trustees of all of New Jersey's public four-year colleges and universities, as well as Board of Trustees of the New Jersey Community Colleges, and the Board of Governors at Rutgers University. Staff also reached out to other state commissions and organizations. A reply was received by Dr. Teresita Sass, Executive Vice President and Chief of Staff, Office of the President of Stockton University, advising that the university supported the commission's proposed changes in the statute. No objection was received to the commission's proposed modifications as set forth in the appendix. The proposed language is added to subsection A2D to clarify that the statute's residency requirement does not apply to unpaid volunteers. The phrase "who serves as an unpaid volunteer" is derived from Cradaville's description of the members of the board. And there are also some grammatical adjustments in some of the other sections as noted in the appendix. Subject to the discussion of the commission, staff requests that the draft final report be released as a final report.
Excellent. Thank you very much, Barbara. Do any members of the commission have any questions or comments for Barbara?
Now, just one quick, I'm jumping in very quickly, Mr. Chair, because we have Commissioner Bell here with us. We did not incorporate his comments in the discussion of the project, figuring he might wish to take the lead on doing so.
Okay, Professor?
Yes, so I have kind of two questions or issues. The first, I guess it's a major one, so I'll go with that one first, which is the language "who serves as an unpaid volunteer." I am a little bit concerned that you could have a situation where someone is appointed to an office that is regularly a paid office, but they're appointed as a volunteer, and so that they could then not have to be a New Jersey resident. I don't think that's what was contemplated by the court in this decision. And it seems to me that someone who has fairly serious responsibility, certainly not in a commission format, probably should be someone who has a residency requirement, and that shouldn't be able to be avoided by appointing a non-resident voluntarily to that position without pay. So if others think that is a problem, I would suggest adding after "who serves as an unpaid volunteer" the clause "in a position that is typically occupied by unpaid volunteers." So should I go on to the second, or do you? And then in the second is the provision above it, which talks about the Waterfront Commission. The Waterfront Commission has actually recently been abolished, and that abolition has been affirmed by the U.S. Supreme Court. And so I'm wondering whether that transfer provision still has any effect in terms of, is there still someone who's working at who was working at the Waterfront Commission on the effective date of the abolition statute, who still wants to be transferred to the Division of State Police in New Jersey and who still lives in New York. There's no particular change, I guess I would suggest for that, but maybe that's something to note in a footnote in case the legislature wants to look at that and update that as just no longer being relevant to anything. So those were my two questions or concerns.
All right, let me take them as you presented them. The first with regard to the proposed language dealing with a circumstance where a paid position is filled by a volunteer, and modifying our project to make sure those are included. Anyone with any questions or comments about that?
I mean, I think Bernie makes a logical point, but I'm just not sure if that's getting into a policy area that was not decided by the court. And I don't have a strong feeling about it. And frankly, I'm recused on this particular item, but I'm just not sure that issue, which does not relate to me, is I mean, it makes good sense what Bernie said. I'm not sure if it's outside of our mandate.
And we have also Commissioner Hartnett wanted to be heard on this one as well, Mr. Chair.
Yes. Oh, I see his hand. Yes, go ahead, sir. Professor.
Sure. I share both Bernie's concern and Andrew's concern. to put a sort of finer point on it, imagine a independently wealthy governor who decides not to take a salary. Does that mean that the governor can live in Florida for as he chooses? That seems like not what the legislature would have intended and not what the court would have expected. But I'm not sure that that wouldn't be the result of the text as it's before us. On the other hand, adding the limitation that Bernie suggests does seem to be getting a little bit out over our skis. Perhaps it's sort of something that's appropriately sort of bracketed and flagged rather than sort of put forward as if we were codifying in that regard. I've got one question, and that is, does New Jersey have anything like the Federal Anti-Deficiency Act that broadly prohibits acceptance of volunteers, except where there's except where there's an exception. It sort of broadly prohibits volunteers, and that comes into play all the time once we hit government shutdowns, because all kinds of people then can't work, even if they'd be willing to, because of the Anti-Deficiency Act. If New Jersey has something like that, that might solve to a large extent the problem that Bernie has raised. That is, if there are positions that are typically paid positions and that's someone by other New Jersey law cannot do on a volunteer basis, I think that solves the problem. But I don't know whether New Jersey has anything like the Anti-Deficiency Act. Justice Long seems to be shaking her head.
I in all these years, I have never heard of a reference to that. Doesn't mean it doesn't exist, but I just have never heard of it.
And on staff, I do not think that we know the answer to that question at this juncture. That wasn't something we had focused on. So thank you, Commissioner Hartnett. And just one other quick note by way of background, we did on staff discuss this and talk about the impact and the suggested changes. And it was this was a project because of the concerns that have been expressed by the commissioners, sort of the interplay of, does this pose a problem, but does it also implicate policy positions? This was a project on which we focused and drafted very narrowly, guided closely by the decision of the court to make sure that we weren't straying outside beyond the parameters of the case.
From my view, I think the case is read fairly to have us assess that it's focused on the nature of the position, not the nature of the person, which is why I think Professor Bell's observation is a good one. And I think I'm less concerned that it's a policy decision than I normally might be, because I think we're talking about drafting it in such a way that honors the letter and spirit of the court decision, which is focusing on the position and not drafting a statute, which, if our work is not modified, is very easily circumvented by having someone decline the compensation and thereby declaring themselves a volunteer. I think the case is about the position, not about whether the person accepts the pay or not. So I think Bernie's comments are worthy of our attention by way of drafting, and I don't think we've strayed from our mission if we do so. Now, we may not want to act on this tonight and have that modified on the fly. That's okay. But certainly I think we can take a look at the language. Bernie, if you'll kindly forgive me, you had a second concern, which I now cannot recall.
Sure, it's about the Waterfront Commission, subsection C, the provision above that. I know that the Waterfront Commission has been abolished, and
Bernie, you could have been a contender.
You're right. Yes. Believe me, a lot of people involved in that case and that controversy have thought of on the waterfront. Yeah, so I don't know whether this still has any impact, because I think it was designed to be a transfer rule, and I'm not sure whether there's still anyone who would be transferring under this. So it just may have become anachronistic. I'm not suggesting any language, but perhaps there should be a footnote or something noting that issue.
Well, yeah, I mean, we don't, as you point out, we don't know if it applies to anyone at this point or not. And if we are not going to act on this tonight in an effort to revise the drafting, as to your point one, it would give Barbara an opportunity to research the Waterfront Commission and can address your point two when this is presented to us again.
Yes, I can certainly do that. And I did look at it, Commissioner Bell, when I saw your comments that were emailed earlier, and it does appear that it was abolished in 2023. Yeah, we can certainly add a footnote. I could look into that more and add a footnote on it.
Mm-hmm.
And the date you're using for abolition, is that the date the Supreme Court upheld the statute? Because I think the statute was enacted several years earlier.
That's right. So the date I found was the United States Supreme Court ruling that it could do so, that it could withdraw, and that the commission was dissolved.
Okay.
All right. Does anybody
Thank you.
any objection to our carrying this to a meeting in early 2025 to attempt through draftsmanship to address Bernie's first concern and to have a footnote crafted as it relates to the Waterfront Commission?
I do think we should research Professor Hartnett's point about the taking the jobs for no pay and whether that is not allowed. Because I think that might inform how we address Bernie's first point.
Yeah, agreed. If we're going to carry it, we'll all learn a little something about that. What did you call it, Professor Hartnett?
Well, on the federal level, it's the Anti-Deficiency Act. I just don't know whether New Jersey has anything equivalent.
Okay, well, we'll add that then to the list of things Barbara should look at. Did you have some further comment?
Yeah, and that is, if it turns out that that with the abolishment and the Supreme Court signing off on the abolishment of the Waterfront Commission, if in fact there is no one who is sort of still on board, who was there in 2017, and he's sort of and he or she is sort of cleaning things up still, so that there's nobody to whom this statute would currently apply, then it seems that getting rid of the anachronistic provision is what is within the mandate of the Law Revision Commission as well. So it seems to me it's worth finding out, because if it's not simply a matter of dropping a footnote, that is, if in fact there's no one to whom it applies, then we should get rid of that or propose getting rid of that as anachronistic.
Yeah, I that's what I had understood. In other words, if there's someone to whom it applies, but it's not going to be lasting much longer, that would be a footnote. If it's defunct as of now, it's going to come out. But that we'll leave that to Barbara to research.
Right. Thanks.
Actually, I do have one more comment on a potential Anti-Deficiency Act, which is that this statute also applies to local and school board units as well. So the Anti-Deficiency Act would have to cover all of those in order for the problem to be fully resolved.
Agreed. Well, school boards you can't be compensated as a matter of law. So I think it's just municipal positions.
Oh, okay.
And Barbara can check that. All right. I thank you then. So we'll see this again, and I appreciate Professor Hartnett. You never know what you're going to find in your stocking. You never know. And it was the Anti-Deficiency Act. So it's not as good as gumbo, but it's still quite a surprise. So
better than coal, though.
That's true, unless you're cold. All right. Next on the agenda is a memo with regard to the enforcement of lost notes. Barbara, you retain the floor.
Thank you. This is an update memorandum on a project that was previously authorized by the Commission in November 2021. The project looked into New Jersey Statute 12A 3-309 to examine the language concerning the enforcement of lost, destroyed, or stolen instruments. The plain language of the statute does not address the rights of an assignee of an instrument when the original version of the instrument was lost before it was assigned. In a Superior Court case, Investors Bank versus Torres, Initially, the trial court noted the facts where the defendants signed and secured a note to Amro Mortgage, which merged with City Mortgage. After the merger, City realized that the original note was lost and filed a lost note affidavit establishing the terms of the original note, and then filed a notice of default and intention to foreclose against defendants, listing itself as the loan servicer and investors as the lender. City then conveyed the right to enforce the note to investors, and investors filed a foreclosure action against the defendants. The defendants argued that investors was not a holder of the note because it did not possess the original note at the time it was lost, and therefore lacked standing to pursue the matter. The trial court concluded that investors proved the note's terms through the use of a digital copy. The appellate division affirmed this decision. The New Jersey Supreme Court then interpreted the legislature's treatment of other statutes, particularly 2A 25-1 and 46-9-9, involving the sale and mortgages of real estate, as supporting the principle that rights arising by contract are generally assignable. The court also examined the legislative goals of 12A 3-309. It observed that UCC 3-309 was amended in 2002 to specify that assignees are not barred from enforcing a note because they did not possess it when it was lost. This amendment, though, was not adopted by the New Jersey legislature. However, the Supreme Court concluded that there was no evidence that the legislature intended this failure to adopt that amendment to displace New Jersey's common law regarding assignments, and it explained that to rule otherwise would contravene established statutory and common law. The commission released a final report that was done by Executive Director Laura Tharney on March 16th, 2023, that concerned the UCC 2022 amendments. And the report addressed a comment that was made in 2022 to this particular code regulation, code 3-309. But the final report also addressed the 2002 amendment to 3-309 and clarified that the assignee was not barred from enforcing a note because they did not possess the note when it was lost. The recommendation was for the legislature to adopt the 2002 amendment as well as the 2022 comment to 3-309. Staff recommends the conclusion of work on this project, since the recommendation contained in the final report, Uniform Commercial Code 2022 amendments, addresses the issue surrounding the competing interpretations of 12A 3-309.
Okay, thank you, Barbara. Anyone with any questions or comments about this recommendation?
I move
So-
that we adopt the staff's
Spencer?
recommendation.
I have a brief, oh, sorry. Am I interrupting someone?
Go ahead.
Oh, okay. Just
Yeah, go
have a brief question. I guess I couldn't really fully follow all the twists and turns. So my question is, as it is now in New Jersey, if you're in the position that the investors were here, can you sue on the note?
Based on the Supreme Court's decision in Investors Bank versus Torres, you could, yes.
Okay, great. Thank you.
Okay. I move that we adopt the staff's recommendation.
Second.
Moved by Commissioner Bunn, seconded by Professor Bell. Any further discussion? Hearing and seeing none. All those in favor? Aye.
Aye.
Opposed? Okay, thank you. And then the final item on the agenda, operating uninsured automobiles. Final report of the year, JC. The pressure is enormous.
Oh, I feel it. I promise.
Okay.
Alrighty, so today I'm going to be discussing an update memo regarding operating uninsured vehicles under New Jersey Statute 39:6A-4.5A. So in New Jersey, motor vehicle and traffic regulations are governed by Title 39 of the New Jersey statutes. New Jersey Statutes 39:6A-4.5A provides that if a person is operating an uninsured automobile and an accident occurs, an action of recovery of economic or non-economic loss is barred. This statute was brought into question in the novel case of Mamudu versus Gonzalez, which highlighted a potential ambiguity in the compulsory insurance law, because although the decedent did not have automobile insurance at the time of the accident, he was searching his disabled car for his cell phone. So on October 26, 2019, the decedent, Mr. Mamudu, was rear-ended on the New Jersey Turnpike and his vehicle was disabled. After that initial accident, Mr. Mamudu re-entered his vehicle to search for his phone, at which point the Gonzalez defendant collided with his vehicle, resulting in Mr. Mamudu's death. A complaint was filed by Mr. Mamudu's estate against the drivers in the first and second accident. The claims against the first driver were dismissed under the statutory bar. However, the court had to consider whether the claim against the second driver was also barred by the statute. So the Gonzalez defendant had argued that Mr. Mamudu was in fact operating the vehicle within the means of the statute. The court disagreed. They reasoned that although Mr. Mamudu was operating the uninsured vehicle at the time of the first accident, neither he nor anyone else was intending or attempting to operate the disabled vehicle at the time of the second accident. And although the term operating is not defined in the statute in question, various applications of the term operate have been discussed in cases regarding DWI law. So, for instance, in State v. Thompson, police officers found the defendant sleeping behind the wheel of his motor vehicle with the engine running. The court said that this fell within the definition of operate under the DWI statute, as even if the vehicle was not observed in motion, it's the possibility of motion that is relevant. In another example, State v. Stein, the defendant attempted to operate a vehicle that had run out of gas. The defendant sat behind the wheel while someone pushed the vehicle. The court determined that in order to fall under the statutory language of the DWI statute, the driver must intend to operate the vehicle and actually attempt to do so. And finally, in State v. DeFrancisco, this considered an incident where the vehicle was entirely inoperable, as it has been stuck in a ditch. The court concluded that intent was not only not proved, its presence, if proved, would be immaterial when operation was impossible. So, as exemplified by these cases, in the DWI context, the court has given broad interpretation to drunk driving laws to comply with the legislative intent to curb drunk driving. Similarly, under the compulsory insurance law, a broad understanding of the language aligns with the statutory goal of giving the maximum incentive to all motorists to comply with the state's compulsory no-fault insurance laws. There is currently one pending bill that seeks to repeal the statute as part of its overall goal of repealing no-fault automobile insurance law and requiring mandatory liability for motor vehicles. This bill was previously introduced in 3 other legislative sessions with no significant movement. And the staff had conducted focused outreach to the New Jersey State Bar Association regarding the threshold question of whether the term operating in the statute would benefit from clarification. At this time, no response has been received. So in conclusion, staff seeks guidance from the commission regarding whether to continue or to conclude work in this area.
Thank you very much. All right, we have a recommendation to conclude work in this area for the reasons stated. Any questions or comments with regard to that recommendation? Okay. Hearing and seeing none, then could I have a motion, please, to accept the recommendation to conclude this project?
So moved.
Second.
Moved by Justice Long, second by Professor Bell. All those in favor?
Aye.
Opposed? Okay. Just a couple of miscellaneous things before we adjourn for 2024. You have before you a list of proposed meeting dates for 2025. Couple of quick comments. I want to make sure everyone's okay with January 16 at 10 o'clock. That's our next meeting. I also want to make clear that We will not meet on June 19th at 4:30. Number one, it's a state holiday, and number two, for a host of other reasons, I think that would be inappropriate. So we'll look at a new date for June, but I would invite people to come to the January meeting and to raise any issues you have so that we can set our schedule for the year while we are all together, just so we can plan, because obviously the January meeting may be too late to do anything about February. Does anybody look at the January and February dates and have any concerns at this moment? Okay, so we should consider the January 16 at 10 and February 20 at 10 to be established. And then we'll talk on January 16, A, to come up with a new date for June, and B, to see if we need to do anything about the dates or times of the other 9 meetings that would remain on our schedule. Okay. Laura, did you have anything you wanted to bring to our attention?
Yes, I do. I have a few very quick updates, but first, Barbara is actually going to jump in with a quick request for guidance for an upcoming project.
Thank you.
Barbara, floor is yours.
Thank you.
You need guidance? Leave
yes.
it on, take the cannoli.
Yes, I am seeking, thank you. I am seeking guidance. The commission previously authorized a project relating to the term household members as used in the Prevention of Domestic Violence Act of 1991. This resulted in a draft tentative report proposing replacement of the term in the statute, as well as several other changes defining persons described as a victim of domestic violence. The commission recommended that additional research regarding the proposals be completed and submitted in a revised tentative report. While conducting research in anticipation of bringing this project before the commission early next year, it came to the staff's attention that a bill is currently pending for the 2024-2025 legislative session in the Assembly with an identical bill in the Senate that incorporates all of the recommendations made in the draft tentative report. This bill was initially proposed in the 2022-2023 session in the Assembly with an identical bill in the Senate. Staff requests guidance on whether to proceed with the revised tentative report, or would the commission rather that staff refrain from further work, as we frequently do when we discover that the legislature is working in an area that we are also working in, or since the bills have not progressed beyond the introduction and referral to committee this session, would you like us to move forward with the work in case concluding our process might generate modifications to our earlier draft statutory language, which is included in these bills, so that we can convey to the sponsors the changes?
When, if you please, Barbara, when were the bills you referenced introduced and sent to committee?
So they were initially introduced in the 2022-2023 session, and they have been reintroduced for the 2024-2025 session.
Were they reintroduced at that's why I'm just want to focus on the timing. Were they, typically you pre-file and you reintroduce the bills that didn't go anywhere. So I want to know if this happened, back in January, or if it's something that happened recently.
So it was January. The initial bill was in January, actually, of 2023.
But for this session,
for this session, it was
2024.
2024, correct. Mm-hmm.
So, okay, so just so I understand, so they were introduced in January of 23, they didn't move, they were reintroduced in January of 24, and they still haven't moved other than having been referred to committee back then.
Correct.
Okay, I think that helps inform the answer to your question, so thank you very much. All right, we have previously given direction to proceed with this project. Does the information, I ask my fellow commissioners, does the information that Barbara just provided lead us to rethink that, or would you like her to continue?
I would recommend reaching out to the sponsors first. I wouldn't want to sandbag them if they're really thinking their stuff's going to move, by coming out with a report 5 months from now that is different and maybe undermines whatever effort they're making. So I want to make sure it's okay with them if we continue to work on this, and that we're not upsetting anybody.
Are
I
the sponsors people with whom we have a relationship? There are some folks who, sometimes reach out to us. They so respect our work, and that would be very helpful if it's any of the sponsors or people with whom we've had a dialogue.
I don't think the sponsors of the bills are people with whom are legislators with whom we've engaged with any frequency. But I will say that normally when we reach out to legislators, even if it's those that we have not dealt with previously, it's usually met with, it's usually well received. So I'd certainly be happy to do that if that's the pleasure of the commission. But since we just found this out, we wanted to make sure that you had the opportunity to weigh in before we moved in one direction or another.
Thank you.
I do have a question. So is the bill that the sponsors have introduced, was that basically taken from our bill, or did they arrive at this independently, or
They
how did that happen?
lifted the language from a draft tentative report that we never released as a tentative because the commission directed at the time that you considered it, you directed that additional work be done. But rather than awaiting the conclusion of our process, this language was pulled from the draft tentative that was never released as a tentative.
Okay, I mean, I would think that they might be interested in further changes that we had, and that would suggest that we actually expedite this so that we could get that to them pending your consultations with the sponsors. And I suppose they might say, well, we don't want you to do anything, but that seems like a kind of strange thing to ask. But anyway, I guess once we know kind of the coordination between the sponsors and whether they want us to do something or not, then it'd be easier to figure out what we want
Where
to
to go.
do.
Sure. And we'd be happy to do that if that's what you'd like.
And if they're willing to have us continue to work on it, then I think we really should expedite it.
Oh, sure.
So that, they have it sooner rather than later.
Thank you.
Okay, anybody take issue with Professor Bell's recommendation? I think it makes sense, and I think it's important, quite frankly, that we continue unless they are disinclined, given that they're basing their work on a draft of ours.
Okay, we will be
Okay.
happy to do that.
Excellent.
And then I just have a handful of quick things. The first of those is for the spring semester, we will have 4 students working with us. We have JC, who will be continuing with us in his role as a legislative law clerk for the spring. We will be joined by Pam Brewster as an extern from Rutgers Law in Newark, and her supervising professor conveniently will be Professor Bell. We will also have 2 NJIT students for the spring as well. Also, the second item on my list is there was movement on the Senate bill that was based on the commission's work on unemployment, the payment of unemployment when an offer is rescinded through no fault of the employee. That was released from committee in the Senate, and I'll be doing some follow-up on the Assembly side bill. Also, third item, Whitney just completed work on our latest article prepared for publication in the Seton Hall Journal of Legislation and Public Policy in the spring. And the last thing is we've been expanding our legislative distribution of our annual report over the years to include not just legislative leadership, but then we added all chairs and vice chairs of the standing committees. Since our distribution is fully electronic and feels not particularly burdensome at this point, unless you had any objection, we'd like to actually send it to all of the members of the legislature rather than just leadership and chairs and vice chairs. The fear is that there are some people that we're missing if we limit it in that way, and especially with the fact that there are a number of new members of the legislature who might not have reached the level of chair or vice chair. We wanted to ask if that was okay with you if we did a sort of the broadest possible distribution of the annual report this year.
Anyone take an issue with the broadest possible release of our fine work?
No.
Excellent. Excellent.
All right, we have a hand raised by a member of the public, William Lim, from the Office of Legislative Services.
Mr. Lim?
Yes, hi, good evening, everyone. Always a pleasure to attend the commission meetings. With the suggestion of a mass distribution, may I also suggest Obviously, Office of Legislative Services, Dave Lorette in Legislative Counsel's office, who can circulate it amongst our staff, as well as the 4 caucus partisan offices, Assembly Democrats and Republicans, Senate Democrats and Republicans, their executive leadership, they are often catalyst of legislation, and then search for members who like where their ideas are going, and then that ends up becoming a bill. So they may also be interested as well.
No, thank you for that suggestion. And just so that you know, when we were mentioning this to the commission, we focused on members of the legislature, but we have historically for more than a decade now sent the report to OLS, and David Lorette is the person who receives it. We also send it to other members of OLS, and we have been sending it to the 4 partisan staff offices. So thank you. But I just wanted to let everyone know that that is part of our usual annual distribution. So we've been distributing it to those individuals as well.
Thank you, Laura. Did you have anything else for us, Laura?
No, those were the only things on my list.
Excellent. All right, I think that concludes our business for this meeting and for 2024. It continues to be a privilege to serve with you. I'm happy that we got 2 more final reports in that will enhance the next annual report, much to Laura's great delight. I wish you all the best for the holidays and look forward to serving with you again in January.
Thank you, everyone.
Thank you.
Best
Thank
wishes
you.
for the
Holidays to
Happy holidays,
everyone.
Happy holidays.
Officially called to order. Let us please stand for the flag salute. I pledge allegiance to the flag
Of the
United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Adequate notice of this meeting has been given in accordance with the Open Public Meetings Act pursuant to Public Laws 1975, Chapter 231. This agenda is complete to the extent known and was sent to the Trenton Times and Trentonian newspapers, posted on the first floor bulletin board in City Hall, filed in the city clerk's office, and posted on the City of Trenton website. Formal action will be taken. Mr. Garcia.
Certainly, Madam President. Roll call. Councilwoman Edwards.
Present.
Vice President Figueroa Kettenberg.
Present.
Councilwoman Frisbee.
Present.
Councilwoman Gonzalez.
Presente.
Councilman Harrison. Councilwoman Williams.
Present y presente.
Council President Feliciano.
Present.
Myself, Brandon Garcia, Municipal Clerk, present. Mr. Edward Kaloji, Legislative Counsel. And City Attorney West Bridges. Thank you. And Madam President, if you'd like, I could read the invocation at this time.
Yes, thank you.
Almighty God, who's the fate of man and nation, we most humbly beseech thee to bless this our city, these deliberations, and these thy servants, that they may act with wisdom and understanding for the good of our community and thy greater glory. Amen.
Amen.
And Madam President, at this time, I believe we have a recognition listed.
Yes,
If you
we
wanted to read
do.
that off, go ahead.
Thank you. Tonight, we have special recognition honoring the National Sorority of Phi Delta Kappa Incorporated Pi chapter, of which I happen to be a very proud member. Whereas the Trenton City Council wishes to recognize the National Sorority of Phi Delta Kappa Incorporated Pi chapter, the 16th chapter chartered in June 1933 here in Trenton, New Jersey. And whereas the National Sorority of Phi Delta Kappa Incorporated was founded in 1923 by Gladys Merritt, Florence Steele, Marguerite Gross, Mildred Morris, Julia Asbury, Gladys Cannon, Edna McConnell, and Ella Wells, and became officially incorporated on May 23rd, 1923. And whereas the members of the Pi chapter have made a commitment to continue to uplift the dedicated educators, classroom teachers, counselors, school nurses, supervisors, principals, directors, assistant superintendents, and superintendents. And whereas the Pi chapter continues to make contributions to the educational community of public schools and civic organizations in the area. and has a very strong relationship with the Trenton Public School District continuing over 30 years. The sorority has spent decades seeking new and better ways to contribute to educational and worthwhile causes that impact upon the development of the youth into positive and productive citizens. Now, therefore, be it resolved, the Trenton City Council hereby recognizes the National Sorority of Phi Delta Kappa Incorporated Pi Chapter and all its members, and thanks each of you for your continued dedication to the students within the city of Trenton and the surrounding areas. Presented this 19th day of December, 2024, Trenton City Council. At this time, if a representative would like to come forward and extend a few words. You have to press the button to turn the microphone on. Thank you.
Good evening, esteemed City Council President, members of the Trenton City Council, honored guests, and community members. On behalf of the members of the National Sorority of Phi Delta Kappa Incorporated, Pi Chapter, I would like to express our sincere gratitude for the tremendous recognition. It is both an honor and a privilege to serve the residents of Trenton, and we are deeply humbled to receive this acknowledgement for our community service efforts. Our mission has always been to educate, uplift, and support our community. And through collaborative efforts with the Trenton School District, Seed Male Mentoring Program, and many other organizations, we have been able to assist students in becoming future leaders, award scholarships, provide professional development to educators, support families, and promote positive change throughout the capital city of Trenton and at large. This recognition is a testament to Pi Chapter's 91 years of focusing on youth education and service, and the collective work and dedication of our members, our partners, and for the entire community that continues to inspire us to do more. Thank you again, City Council President and members, for this honor. You have truly inspired us to keep moving forward in our pursuit of excellence in education for all. Thank you.
So if you don't mind, we'd like to take a quick photo with everybody. It's a lot of y'all here. Yeah, so we're gonna go out to the staircase in the hall really quick. We ask everybody to extend us your patience while we go do that. Mr. Garcia, did you notice that Councilman Harrison is here? He is present.
Thank you, Council President. I've marked him present as of 5:37 today.
Thank you. If Jorge could accompany us to help with the pictures, we'd appreciate it. Thank you.
He'd be delighted.
They're addicted. So the thing I can say is they're addicted. Say, let's go. It's really bad. It's a nice boast, isn't it? I was in second.
Just get the concept and some criteria that the box actually is.
First degree in these minutes.
The terrorism.
Yes.
I saw it. Maybe it's the.
Mr. Garcia,
On your call, Madam President.
thank you. Before we adjourn into executive session, there is one other presentation that I wanted to do. It is the corrected resolution honoring and commending Trenton City Councilwoman Yasminelli Gonzalez upon her appointment to the Electoral College for the 2024 presidential election. This is a historic moment for the councilwoman. It's a historic moment for the city of Trenton. And she actually went and appeared on the 17th, on December 17th, she appeared at the State House in her capacity as an elector and cast her ballots for the Democratic candidates in the recent presidential election. So we want to congratulate you once again, Councilwoman Gonzalez. Job well done. Yeah, okay.
I just want to thank you all. You didn't have to do it again, but thank my colleagues for recognizing me. It was an incredible experience, and I just want to say thank you so much.
Absolutely, absolutely. With that being said, may I have a motion to go into executive session?
So moved.
Second.
Roll call, Councilwoman Edwards,
Yes.
Vice President Figueroa Kettenberg, Councilwoman Frisbee,
Yes.
Councilwoman Gonzalez,
Yes.
Councilman Harrison,
Yes.
Councilwoman Williams,
Yes.
Council President Feliciano.
Yes.
Motion carried. Madam President, do we anticipate a vote coming out of executive session this evening?
Huh?
Council President, if I may.
Yes.
We do not expect a vote coming out of executive session. I just want to provide for the record that one of the purposes that we're going into executive session is to discuss personnel issues, many of which touch upon current pending litigation, as well as litigation that may be brought by the city of Trenton against different entities or individuals. So for that reason, under the anticipation litigation, current litigation, we're going into executive session.
Right, but we're not expecting a vote to come out.
That's correct.
All right, so can I have a motion to go into executive session? Did we do that already?
We
I
did.
believe
Okay,
you've already taken care of that part.
Okay, so let's go. Thank you.
Okay.
Cool. That makes me worry. All right.
How you doing?
One on this end. That's Kenneth Douglas Park. Kenneth Douglas Park. It's the meta.
They sent him some. They do the CD. To the CD. He sent me to. He does the CD exercise. Nice. She had a fight. Yes, Yes. It also looks Hello. So the way they see who's working out. I don't know if it's and stuff like that. I would like to see. I was trying to get it from I want to say I started So I get my own. Oh, actually, but I'm supposed to get. I want acre house. I have some acre house. They have. And I'm just like, I want my kids. Yeah. Yeah, wait, because.
To do it.
She had the right. You can't, she doesn't, Bryce knows how to issue. Bryce knows how to issue. Properly or improper. Issue a price. Issue price. Yeah. Right, and the price nation, he actually, yeah, they budget, they did not go through rights, one council city.
It's like a family.
Stop this.
They all have their
Council, I'll jump in other councils, and the research, and I, it's like, stop starting, that's my. So. She. Yes. Right. What she really wants. So when I say. You always have the right to body. So yeah, that's. I think there's. She was saying she had majority vote to have the best solution. Yeah. You don't need it. That's price. You don't need to. That's the issue. So it's not. Man, talking about that. The best nation to do this. I say it's not doing this, right? I said, do it right. No, it's his right. Right. So, yeah. Right. So, executive session, wait. That makes no sense. You have to go for executive session, right? Somebody, because after the executive session, you raise them, you gotta give them, what, 48 hours notice, what? You said. Oh, that's no. With notice, you do, executive session. No, I'm not saying. If they want to. No, but here's the problem. Myself, your supervisor. They have no authority. They have no oversight. That doesn't matter. They have no, you're only answerable to even if you're not. You're not answerable. They can raise me, you have no.
Mhm.
On your call, Madam President. Oh, shoot, where's mine?
We're gonna start in about 3 minutes. Thank you.